Yes, my lords.
18,242, delay of 242 days.
Yes, my lords.
You are
A short
appellant?
recommendation.
You are appellant,
For respondents, my lords.
respondent. Then we'll issue notice in delay.
Sorry, my lords.
We'll issue notice in the delay application.
My lord, I appear for the appellant. My lord, they're on caveat on behalf of respondents.
18th, we issue notice returnable on 20th February.
20th
February.
February. Oh,
Very well.
That's serial number 15. When
15.
I
Yes.
appear for appellant, I
Hmm.
request for short accommodation. I request for short accommodation.
At the request of learned advocate, Mr. Mohammed Tahir,
Yes, ma'am.
must stand over to 21st February as requested. Yes, next.
Kind permission. Contempt matters. The seal number 1. The Narsimurthy K. I appeal for the response.
Lord, compliance affidavit has been filed, my lord.
So this was for orders.
Lord, the
Contempt 38 of 23. The statements made in the affidavit referred to above are perused along with the contents of the endorsement dated 18/3/23 and later dated 10/6/24 addressed to Special Land Acquisition Officer. The statements in the affidavit and the contents of the document filed along with the affidavit would substantially mark compliance of the directions in the order under contempt. In the light of the above, this contempt would not survive for further consideration. Accordingly, it is disposed of. However, it is provided that the complainant has liberty to avail remedies as available in law against endorsement and later referred to herein above.
Seal number 2. The Ram Mohanam.
I am for the contempt.
Test, ma'am.
But I learned that they filed,
Compliance affidavit is filed, my lord, on 20.
I have not received the copy. I have not received the copy from the respondent side, accused side. If they furnish, I will submit my arguments next week.
Yes, you filed some
I
complaint.
will give it right away.
Give this. Copy should be given to the other side first so that it is,
Understood. Out, my lord.
it is filed in the court record. So it is complied.
My lord, we have issued an endorsement, my lord.
Yes, I have received the copy.
So it is, order is complied.
I will submit my argument
What argument?
next week
What argument? It is
regarding whether the,
that argument can be in separate independent proceedings. You challenge this endorsement,
yes, I will.
will dispose of it. Following directions were issued by learned civil judge in order dated 3rd August 2022 while disposing of the writ petition number 20994 of 21. So paragraph 3 may be quoted, page 12, this flap. Post of. Respondent have filed affidavit compliance in which it is inter-alia stated that
Page 33 R6 is the endorsement, my lord.
that endorsement dated 14/9/23 is issued. And it is explained to the complainants about the various issues and it is communicated and it is further stated that complainants are communicated that Saguwali cheat cannot be issued in their names for the reasons stated in the endorsement. Full stop. The above action on part of the respondent in issuing the endorsement marks the compliance of the directions of the single case. Therefore, the present contempt petition is liable to be disposed of. Paragraph. The petition is accordingly disposed of as not surviving. Paragraph. It is our clarified that if the petitioner has any grievance about the endorsement, it is open to the petitioner to challenge the same in appropriate independent proceedings in accordance with law. In respect to which, however, this court does not express anything on merits.
Number 3, to A. Madhusudan Rao.
The complainants. My lords, the predecessor and title of the complainants was granted land in the year 1983, my lords. Ever since after the death of the predecessor and title of the complainants, they have been in possession of the land. Sagu chit has not been issued till date, my lords. Initially in 2013, a writ petition was filed before this honorable court seeking for a direction to the deputy commissioner to issue the Sagu chit. That writ petition was disposed of with the direction that within a period of 6 months, the representation had to be considered.
Issue notice,
Much obliged. my lords.
8 January.
Much obliged.
So number 4,
Appearing for Lord complainant. This is my Lord order at page number 31. Passed by learned single judge on 11th June 2024, my Lord. Page 6, my Lord, may kindly be seen in page number 31, page 6. In the light of the submission made by the learned counsel appearing for the parties and perusal of the writ petition would indicate
Yes,
that the petitioner has
Notice
produced
returnable on
judgment and decree.
notice 11th January.
Please, my Lord. Much.
this is number 5. Shrimati Anuparna Bordale.
Hearing for complainant, my lords. This is second round of contempt, my lords. In the contempt petition, my lords have passed an order at page 19, whereby they themselves have undertaken that they will comply with the previous order. They have not complied till today in spite of issuance of the notice, my
What
lords.
was the order?
The order here, my lords, will get it at page 22, whereby the
No.
single judge had directed
Page-
them to
Page
deposit.
22.
Page 22, my lords.
Oh.
The relevant portion, my lords, will get it at page 30, para 9.
Page 30.
Please, my lords, page 30.
Oh.
Para 9 is the order on which we had filed a contempt. 20.
Hmm. Good.
They appeared before this honorable court and made a submission that they will be complying with the order.
So some amount is to be deposited.
Please, my lords. Yes, my lords.
Amount is to be paid.
Please, my lords.
Towards what?
My lords, towards land acquisition.
Notice written on
Yes.
17th December. This is second round there.
Aye.
to P. N. Harish. 6.
This honorable court, my lord, as per annexure A, my lord, page number 12, para number 6, directed the respondent authority APMC to effect the kata and to give an NOC for installation of our equipment. That order it came to be passed on, my lord, on 18/5/2024, directing them to do it within a period of 2 months. Till this day, my lord, they have not complied it. I have purchased the property in the year 2016, my lord. Till this day, I am not able to use the property because of non-sanctioning of our connections.
Notice written on 21st January.
Please.
Number 7, to Devaya.
My lord, for the complainant in this matter, my lord. My lord, the order is at page number 33, my lord. An order of, an order passed by the coordinate bench of this honorable court. Page number 40 is the undertaking given by the accused to complete the project. My lord, it's a developer and he has undertaken before this honorable court in certain settlement proceedings and a COMAP, an appeal, wherein he has undertaken to complete the construction work by October 2023 and to hand over possession by November 2023. I have produced the photographs, my lord. Even till today, the project is not complete. I have produced the photographs at page number 114. It was in pursuance to this order that, my lord, all disputes came to be settled. Page 40 is the undertaking.
Notice returnable on 10th February.
Grateful, my lord.
Number 8.
Lord petitioners, my lord. Order, my lord, page number 11. Operative portion is, my lord, page number 13. There is a direction to the respondent number 2 and
Notice written on 11th February.
grateful, my lord.
Seal number 9. Mr. Ranganath S. Joyce.
Mela,
Number
appear
9.
per complainant, Mela. Page number 20. Annexure C is the order, Mela. Operative portion of the order, page number 24, paragraph 5, Mela. In that view of the matter,
Notice
petition is
returnable on 23rd January.
much of it.
Seal number 10.
Complaint.
Sridhar Murthy.
My lord, order, page number 10, order passed by this honorable court, direct the accused person to consider the complaint representative.
Notice written on 11th February.
Seal number 11.
Same, my lord, connected matter.
Same order.
Green bench matter. Seal number 12. Ganpati Bhatt.
This case, my lord, I am appealing for petitioner. The specific prayer which sought, my lord, is direction to the respondent number 6 to 8 to provide police protection and to take appropriate action by the competent authority, my lord. This is, my lord. Auction receipt. Annexure E ink page number 62, my lord, is very relevant. Translated copy 64, my lord. (64), can I read? Subsequent to amendment of KMMRC rules, my lord, that state government has started auctioning the, my lord, crusher blocks. Accordingly, my lord, this is handicapped reservation under the KMMRC rules, and accordingly, my lord, the paper publication has been made and I have applied under the quota, and thereafterwards, my lord, in page number 64, my lord, the order has been issued. And accordingly, my lord, 64, my lord, 65 page, column number 2, the annexure, Vinay S.N., my lord, right side, 65, page 65, translated. This is the order passed by the state government. And thereafter, my lord, order came to be passed for granting me, along with the sketch that I have produced. And subsequent to that, query lease has been executed in page number 73. Translated copy, my lord, this is in English. Thereafter, my lord, the query lease has been executed, my lord, the survey has been conducted. Thereafter, adjacent, my lord's respondent number 9 has started illegal activities, and we have given representation to the all the department saying to provide protection. But, my lord, he has no query lease at all. And, my lord, the property which is scheduled, which is, my lord, kindly see, schedule, my lord, e-setting page number 76. That is, my lord, survey number 54, 1 acre 20 guntas has been query lease executed. Thereafterwards, my lord, the this ninth respondent, my lord, having no any rights, and this is query lease has been executed after conducting, my lord, the auction, and, my lord, boundary has been fixed and query lease has been executed. Thereafterwards, my lord, that he has started interfering. we have given a representation in page number 135 annexure M to Deputy Commissioner and competent authority, Assistant Commissioner Tahsildar, to, my lord, provide protection. And since, my lord, that I have taken under, my lord, auction regime, I have complied all the conditions, and my lord, this block has been identified by the state government itself. But required amount also has been paid by me.
That is all. Your suit is pending.
Please, my lord.
Suit is pending, injunction is granted.
That injunction, it is my respectful submission, injunction that we have obtained, despite of that, my lord, that the illegal activities, my lord, I may be, the police may be directed to give protection, my lord.
Go before the civil court, whatever prayer you wish.
I have not suppressed any material fact. No. No. Volume number, my lord, 314 may kindly be seen for a moment, my lord. W and spot merger 309. 309. Spot merger at 309. Lord. Can I read, my lord? Joint survey also has been conducted. Kindly see in page number 314, my lord. But, my lord, he has no rights. And, my lord, joint survey has been conducted. I have paid amount. I am genuine.
Sorry, or learned advocate.
Kindly see for a moment, my lord, that I am genuine, my lord, that this is not application has been made. Government has identified, and, my lord, the government has executed by taking required amount. And it is duty of the state government to protect me. Therefore, my lord, I am seeking. Kindly see injunction, which is in page number 318, which we have filed, my lord. Injunction also granted. But I can't, my lord, fight in the spot because he's a spot merger conducted. Tahsildar has, my lord, ordered to survey. Under those circumstances, my lord, whatever required amount that we will pay, my lord, we will pay. My respectful submission is to direct to provide police protection by taking required, my lord, fees. Since, my lord, that I have made all efforts, that is my humble request, my lord. I have no other way. I have deposited amount. Now I can't execute being a handicapped person. My lord,
Heard learned advocate Mr. So-and-so for the petitioner and learned additional government advocate Srimati Neelofar Akbar, who appeared upon service of copy of the petition in advance by invoking paragraph from the jurisdiction of this court under Article 226 of the Constitution. The following prayers are advanced by the petitioner and Roman 1, 2, 3, 4 bracketed portions at page 23 and 24 of the petition. The case of the petitioner is that after undergoing the necessary procedure, including the identification of the property from a respondent authority registered a co-release dated 2/6/23 in respect of co-release number 1117 in respect of the property bearing number 54 at measuring 2 acres at Sankanhalli village, Nagamangala Taluka, Mandya district, in favor of the petitioner, which was a lease for extracting ordinary building stone granted for 30 years. Possession was handed over after fixing the boundary. It was stated by the petitioner. It is the case paragraph of the petitioner that when the petitioner went to the schedule, when the petitioner went to the site of the quarry lease area, this one was 5 years. Was found to have removed the boundary fixed by the authorities and had started illegal extraction of the mineral from the scheduled property. It appears that the complaint was submitted and FIR was also lodged by the petitioner. It is the case further that respondent 9 and his family members physically attacked the petitioner. Paragraph. It is further stated that even drone survey was conducted by the Taluka supervisor and the report is submitted. It is the case that it would go to show that the respondent 9 was engaged in the activity of illegal extraction of the building stone material. Petitioner has thereafter stated that since he was frustrated, he approached the civil court by filing original suit number 272 of 2023 before the court of learned, before the competent court at Nagamangala, competent civil court at Nagamangala, against respondent 9 by producing all relevant materials. Paragraph. It is an admitted position.
Injunction also granted.
Pleaded by the petitioner himself that in the said suit instituted by the plaintiff against very respondent 9, against whom the allegations are made in the present petition, the civil court has granted injunction restraining respondent 9 from interfering with the possession and enjoyment of the leased area. Apart from the aspect that the case pleaded in the petition, in the present petition, that the respondent 9 is engaged in the illegal extraction of the leased area, stands at variance with the case put forward in the suit that the petitioner, that the respondent 9 is undertaking agricultural activities, the ground which dissuades the reason which finally, the reason which would dissuade the court from exercising its jurisdiction, extraordinary jurisdiction, is that in relation to same subject matter and against the very respondent, the civil suit is pending and the petitioner plaintiff has obtained injunction also. Also, it is open to the petitioner to pursue the civil remedy, which is already availed by him, full stop. On the said ground alone, this petition is not entertainable and accordingly dismissed without going into the merits of the case. As such.
Can I make one submission? I have approached everyone, deputy commissioner, Tahsildar, assistant commissioner, everyone, civil court.
The prayer which is thought to be advanced
Lord,
in the present writ proceedings could be advanced before the
no.
civil court in the pending suit.
Can it be one observation?
Accordance with law.
Jurisdiction police, I may permitted to approach by producing the order.
That we have said.
Writ appeal matters, seal number 13, Hegre Prashant.
For the appellant, Your Honor.
Pardon.
And for the appellant.
Delay, notice returnable on February 12th.
December 4,
So, not
14.
February 12th.
Appearing for appellant.
Notice
Please, great.
in delay.
15 adjourn, seal number 16, Mr. M.B. Chandrachud. Seal number 16.
For the appellant, my lord, is like in other court, my lord. Kindly pass over, my lord.
Pass over is not possible.
Have it next week at least, my lord. Next.
On the ground of alternative remedy, my lord.
Alternative remedy, my lord. I am a proxy counsel, I cannot. I am a proxy counsel, my lord.
Pardon?
I am a proxy counsel, my lord. Counsel for the appellant legs in other court, my lord.
Keep back. 2:30, 2:30.
2:30, my lord.
Next.
Number 17. Mr. Saravana, yes?
Satya for the appellant in this case. As a matter of fact, my lord, she only requested extension of time to confirm the sale.
It will revive your right. Extension of time for what?
And your lordship's subsequent judgment will come in the way, my lord.
Canara Bank.
Lordship's judgment was passed on 16/10/2024.
16th October.
Yes, my lords.
Yes.
But one issue, my lords. 10% was deposited on 21/6/23. They had called me, my lords, by giving only 5 days time.
We approach the authority, withdraw the.
Lords, I may be given liberty to approach again the bank, my lords, on humanitarian grounds if they consider, my lords.
While unable to dispute the law laid down by this court while unable to dispute the position emerging from law laid down by this court in Canara Bank versus Mr. Subramaniam Rao K. in writ petition number 349 of 2024, decided on 16th October 24, learned advocate for the appellant seeks to withdraw the present appeal by submitting that the appellant may be permitted to approach the authority concerned for making appropriate prayers. Full stop. The liberty is reserved. However, any opinion on the merits is not expressed by this.
Grateful.
Appeal is disposed of.
18 is urgent. Still number 19. Please, Shweta Anand. 19.
Yesterday, similar matter was listed. It is pertaining to EPFO international workers arising under the very same judgment. It has been ordered to be listed on 30th January, my lords.
30th.
30th January.
1/3.
30th 30.
30. So
30.
here also notice written.
Yes, sir.
30 January.
Obliged.
Still number 20. Sharath S. Gogi.
Notice returnable 20, delay
Hearing for.
on 20th February.
Grateful your.
Still number 21.
Kindly pass over the case, my lord.
Rajeshwar PN.
Kindly pass over the case, my lord. Senior is held up in another court.
Who appears?
P.N. Rajeshwar. Senior man.
Who?
P.N. Rajeshwar.
What is it about?
My lord, it is challenging the petition number 8685 of 2014, my lord. Challenging the order date. Senior wants to make his submissions, my lord. Kindly pass it over.
Sorry, my lords. Somebody agreed by that portion of the order, my lords. From para 28 onwards, page 46. I am of the considered opinion that equities can be balanced with the requirement of compliance with law by directing the petitioner to make a fresh application to the KIDB for sanction of plan in terms of the applicable building bylaws to the concerned area within a period of 1 month from the date of receipt of certified copy of this order. Said application for plan sanction shall be considered by KIDB in terms of the applicable building bylaws within a period of 1 month thereof. On such sanction, within 2 weeks thereafter, the judicial engineer of the KIDB shall issue fresh prior notice, visit the property of the petitioner to ascertain if the construction is in terms of the plan sanctioned building bylaws. If the same is, then issue the necessary occupancy certificate. If the same is not, then issue necessary notices indicating the deviations and or violations of the plan sanctioned building bylaws, accompanied by a sketch of such deviation, calling upon the petitioner to remove such deviation and or violations, which shall be so removed by the petitioner within a period of 60 days thereafter, and the construction brought in compliance with the plan sanction.
Earlier plan was approved.
Plan was granted by Panchayat, my lords. Panchayat initiated action. Panchayat initiated action, my lords, that was challenged. That single judge has held that is the authority. Panchayat was not the authority. But the building was constructed with the Panchayat plan, my lords.
Very reasonable. Heard learned senior advocate Mr. So-and-so, assisted by learned advocate Mr. So-and-so for the appellant and learned additional government advocate
Respond number one.
Harish, who appeared upon service of copy of the appeal in advance. The challenge in this writ appeal, challenge this appeal under section 4 of the Karnataka High Court Act 1961 is directed against judgment and order dated 27th September 2024 of learned single judge. Full stop. The operative portion.
Page 48.
The writ petition came to be allowed, paragraph, not operative version. It was the writ petition was partly allowed from order dated 26/2/15, passed by respondent 1. The Bangalore Urban Jilla Panchayat came to be set aside, and the authorities were directed to implement the above directions within the time frame stipulated. Paragraph. The above referred order dated 22/15, which is set aside, was the order whereby the Jilla Panchayat had directed demolition of the property of the petitioner. Full stop. While setting aside the said order, the directions came to be issued by a single judge. Full stop. The directions are found in paragraph 28 to 30 of the judgment reproduced here and there. So quote paragraph 28. Therefore, 28 to 30. Full stop. Noticing the relevant paragraph after quoting, noticing the relevant facts in the background. The petitioner happens to be a proprietor of a hotel run in the name and style of Messrs. Vishnu Hotel, which was constructed on plot number 256-A1 in Bomma Sandra, Bomma BOMMA SNDRA, Bomma Sandra Industrial Area, Anekal, Taluka. The land was allotted to the petitioner as per letter dated 21/12/95 by the Karnataka Industrial Area Development Board into bracket KIADB. It appears that the petitioner approached the Bomma Sandra Gram Panchayat seeking a sanction of the plan of construction on the said plot. The plan was granted. Petitioner put up construction. The KIADB issued notice dated 21/6/13 to the Panchayat Development Officer, Bomma Sandra Gram Panchayat, requiring the Panchayat to cancel the license issued in favor of the petitioner. It appears that the said letter was subject matter of challenge in the writ petition number 3082/13, which was disposed of by the court on 4/8/21, treating the letter as show cause notice. Also, the petitioner to give an opportunity of hearing. Finally, order dated 26/2/15 came to be passed by the Jilla Panchayat on the ground that the construction was required to be demolished since was in breach, since was not legally put up. Thereafter, the state of Karnataka, through its commerce and industries department, as well as urban development. Thereafter, the stand of the state of Karnataka, through its commerce and industries department, as well as urban development department, was considered. Full stop. What was concluded finally was that the plan sanctioned by the petitioner was wrongly obtained from the Gram Panchayat, since the Gram Panchayat was not vested with power to sanction any such plan for the industrial areas, public estates, and that it was KIADB, which was the competent authority to sanction the plan and examine the aspects whether the construction is legally put up. Learn a single judge, noticing that the Gram Panchayat had no authority to sanction the plan, and observing that the Gram Panchayat acted without jurisdiction and that it ought to have refused the sanctioning of the plan, since it could not have acted beyond its authority, issued the above quoted directions in paragraph 28 to 30. The order which was passed by the Jila Panchayat dated 26/2/15, requiring to demolish the construction, was set aside in favor of the petitioner. Full stop. The directions paragraph issued by a single judge only require the petitioner to make a fresh application in terms of the building bylaws of the KIADB, which shall be examined by the KIADB, and the final decision shall be taken as to whether any violations have taken place. Full stop. When the order setting aside of when the setting aside of order dated 26/2/15 is juxtaposed with when the factum of setting aside of order dated 26/2/15 is juxtaposed with the directions issued by Learner Single Judge, it could be well said that Learner Single Judge has balanced the rights of the parties in giving the directions and disposing of the petition on those lines. Full stop. The order of Learner Judgment and order of Learner Single Judge paragraph could be said to be eminently proper, legal, and reasonable, booking no error whatsoever, so as to require interference in the appellate jurisdiction. The appeal is dismissed.
Lords, may I make one request, my lords? Within 1 month, I had to make the application, lords. 1 month is over. I may be given some extension of time from.
You have got your hotel running or not? Then very good.
My lords,
On the contrary, far better order in your. Yes, next.
Still number 22. Srimati Vaishali Hegde.
For the petitioner, please, Your Lordship. The impugned order, it's not an interim order, Your Lordship. May I kindly see? It's at page 25. It's not an interim order. It is the second main prayer in the petition.
It is interim order.
It is not an interim order. It's passed during the pendency of the petition. The petition is still pending, but it's not an interim order because I will just read it and then take Your Lordship to the prayer. She so-and-so learned thing submits that he has now been instructed to appear in the matter, given 10 days to file statement of objections. Objections, if any, to be filed by 5/12/2024. Pending consideration of the matter without taking into account, pending consideration of the matter taking into account that neither a challenge evaluation nor a re-evaluation is permitted under the rules, and taking into consideration that the petitioner is likely to lose an academic year on account of the same, respondent 2 and 3 are directed to carry out re-evaluation of the papers of the petitioner through a different evaluator though the evaluator who had evaluated the answer scripts of the petitioner on the earlier occasion within 1 week from today, relist on 9/12. Now, your lordship may kindly, I know it looks very innocuous, but your lordship may kindly go to the main prayer, page 46
44.
of the writ petition of the compilation. Page 45 is where the prayer start. Prayer, wherefore so and so, so and so. Now that is the first prayer. The second prayer, your lordship may kindly say. Issue a writ in the nature of mandamus or any other writ. A writ by directing the respondents to conduct re-evaluation of the examination papers in veterinary microbiology held on so and so, so and so. This is the main prayer. Now I may also, I'd like to narrate the facts leading to this present. The petitioner, your lordship, was a second year student of veterinary science. After taking the main exam, she failed. She asked for retotaling. Retotaling, it again came as failed, no change. Then she was before this honorable court in an earlier writ petition. That judgment I have produced at annexure at page 50, page 134, please, your lordship, may kindly say. Page 131, your lordship may kindly take.
Yes.
Now, this was the same petitioner. This December, this judgment is 8th December 2020.
Same petitioner.
Same petitioner. She was before this honorable court. Your lordship may kindly see the prayer. In this, this writ petition is filed under Article 226, 227 Constitution of India, praying to direct the respondents to conduct re-evaluation of the examination paper of the petitioner in veterinary microbiology held on 30/6/2023 and 1/7/2023 and permit the petitioner to see her examination papers. This was that. This was, now your lordship may kindly see the final order. The petitioner has filed this petition seeking direction to the respondent to conduct re-evaluation of the examination paper of the petitioner in veterinary microbiology held on such and such a day and permit the petitioner to see her answer script. Learned counsel for the petitioner submits that he will confine the writ petition only to the extent of permitting the petitioner to see her answer script. So they gave up their second prayer.
Learned advocate Miss.
Vaishali Hegde.
Vaishali Hegde. While assigning the impugned order. Dated
Dated
25th November 24. Passed in the proceedings of writ petition. Could successfully submit that though the apparent nature of the order is interim, it has definite traits and trappings of finality. In this regard, learned advocate for the appellant drew attention of the court to one of the prayer, in particular, prayer Roman small 2, made in the writ petition, which is for direction against the respondents to consider the re-evaluation of the examination paper of the petitioner in veterinary microbiology held on 30/6/23 and on 1/7/23. It was therefore submitted that the order which is passed permitting the directing the authority to carry out the re-evaluation of papers of the petitioner amounts to granting of principal relief at the interim stage. Not only that, it was further highlighted that earlier writ petition number 20715 of 23 was filed before this court by the very petitioner in the very subject, and the prayer for conducting the re-evaluation of the examination paper was given up, and the only prayer which was pressed in the petition was to the extent of permitting the petitioner to see the answer sheet The order in the said petition figures on record into bracket page 131 to page 133 bracket over notice returnable on 5th of February by ad interim leave, the impugned order of learned single judge dated 25th November 24 shall remain state. This order will not be a bar for the single judge to proceed
Please,
with the writ petition
please,
and decide it in accordance with law,
please.
without being influenced by the present.
Yes, yes.
It's a commercial appeal, seal number 23.
Here for the
Shankar.
appellant.
Represent the caveat respond number 2 for this case. My lords.
22. 22 is this, now. 23.
Lords, I may have to file my objections to the application filed by the appellants, my lords. I pray for some time in this. I may have to file my objections to the applications filed by the appellants hearing.
You are a defendant.
I was a plaintiff, my lord, before the trial court. my lord. I was the plaintiff before the trial court.
You are a plaintiff.
Yes. I was absolute owner of the property. It is decreed, no doubt, my lord. What happens is, I was the sole owner of the property.
But this decree in your favor?
My lord, what has happened is, it says jointly, my lord, in favor of my son who's invalid, and my lord, wife, my lord, who has thrown me out of the house. They have now colluded, my lord, the builder and these two people have colluded. My son, my lord, is invalid in the sense, my lord, he is mentally, my lord, unsound. That's, my lord, admitted fact. What has happened is, it was my self-acquired property. My father was absolute owner. There was a partition, my lord, between me and my brothers. It's not a joint family property. I, my lord, because the builder wanted, my lord, their name to be put, my lord, I put it. In fact, this honorable court, division bench has held. Normally, my lord, when there's a sale or something of this kind, they, my lord, put, my lord, the wife and the son's name, but it does not become, my lord, the joint family property. My problem is, my lord, this. I'm now thrown out of the house. The builder, my lord, does not want to give it, my lord, hand over, my lord, the possession. My lord, the order is jointly give it to both, all the three parties. Therefore, I am aggrieved, my lord. My prayer was, my lord, to give it to me. And that, my lord, even the second and third respondent did not object to it. Now, my lord, the order is, prayer is for handing it over to me solely. Order is give it to all the jointly, which means, my lord, it will never be handed over. Therefore, I am,
may I submit, my lords? The suit is one for mandatory injunction, my lords. The suit is based entirely on a joint development agreement, my lords, that has been entered into between the developer and the owners. Let me kindly peruse the joint development agreement, my lords. It is at page number 45 of the compilation. My lords, owners referred to the joint development agreements are the appellant herein and the respondent number 2 and 3.
So this joint agreement is between whom?
Between the
Sharing agreement.
Sharing agreement, my lord, is between, my lord, all the three of us, because he wanted my wife and my son to be named there. But if your lordship turn to, my lord, page 48, please look at 48. 48, third unnumbered paragraph. Hanumant Rayappa was my father. He was, my lord, the owner of this property bearing survey number, my lord, 31 of Batrahalli village. Third paragraph, my lord, at page 48. There was, my lord, between us, myself and my siblings, there was a partition. It's not an ancestral property. Builder wanted, my lord, my wife and my son's name to be put there. In fact, my lord, this honorable court, division bench has held. In such circumstances, my lord, doesn't become, my lord, the owner, my lord, the ancestral property. It can't be termed.
Where is the plaint?
My lord, didn't tell you that.
Subject matter before the trial court was very limited, my lords. The direction was sought to direct the builder to hand over the position of the owners constructed area to the owners. Who are the owners?
whether the
Whereas-
appellant alone is the owner, my lords,
Madam,
that's a subject matter, my
please.
lords, in other suit. There is suit pending, my lords, consolidated suit for
Yes.
partition is filed, that is pending before the civil court. My lords, the prayer and the suit is very limited, my lords, wherein they have sought a prayer to direct the
Statement.
builder to hand over the possession to the owners. The trial court, my lords, that relied upon the joint development agreement, my lords, in the joint development agreements, the appellant herein and respondent number 2 and 3 are the owners. My lords, limited prior, my lords, the trial court has rightly, my lords, allowed the, when defeat the suit, directing the builder,
Respondent is not party in the agreement.
they are, my lords.
Where is the page is
My lords, agreement, my lords, is at page number,
45.
yes,
Yes,
my
ma'am.
lords. 45.
Where are you?
My lords, between Sri B.S. Naranappa is the appellant. Srimati C. Rukmini and Master B.N. Pawan Kumar, they are the respondent number 2 and 3.
Your Urban Properties Private Limited. Then Srimati Rukmani and
Yes.
PM, where are they?
My lords, joint development agreement, is page number 45.
Right? You are there.
They together represented, they are the owners of the property.
Please look at the recital, my lord.
Number 1 is not.
My lords.
Number 1 is, my lord, the appellant.
Number 1 is the appellant.
No, he is not party to the agreement.
He is, my lord.
Is party to the.
Where is
Please come to, my lord, page 45, Narayanappa,
40?
45, my lord, 45.
The appellant number, appellant is
Narayanappa.
Naranappa, my lords. The party number 1 in the
Meeting.
joint development
Pawan
agreement.
Kumar.
This messes. Hebron.
My lord, Hebron, my lord, what has happened is,
Hebron.
Vineyard Properties has now changed its name.
They are changed, yes, yes.
That's why, my lord, there was some confusion. I also, my lord, initially, some confusion. My lord, please look at, my lord, page 48 for a minute. Unnumbered paragraph 3.
Page 48.
48, my lord, yes, 48. Third unnumbered paragraph. Whereas the lands in survey number 31 of Batrahalli village, Bangalore, South Talu, now East Talu, Bangalore, originally was the ownership of Sri Hanumantarayappa, and after his death, property left behind by the said Hanumantarayappa were divided by meets and bounds by a partition deed in the office of the sub-registrar, whereas that is, my lord, between the legal heirs of Hanumantarayappa, that is, my lord, my siblings. Whereas all the properties left behind by Hanumantarayappa were partitioned by his legal heirs, and owner number 1 acquired 2 acres prescribed in so and so, and is the absolute owner, my lord, of that property. We put their name because the owner, my lord, the builder wanted, my lord, their names to be put so that, my lord, he doesn't have any problem. My suit,
It is survey number 31 only.
yes, my lord.
My lords, before the.
My suit, plaint, my lord, if your lordship sees,
Plain very.
Lord, court master, plaint, could you? Prayer, my lords, get that at page 13, 1-3. Pass a judgment and decree by a grant of mandatory injunction against the defendant to hand over Schedule A, B, and C items of properties as per the sharing agreement, and which is registered at so and so, in fullness and completeness to the plaintiff. Now he says, my lord, give it jointly. The order is. Page 36.
My lords, in a suit,
And the division bench of this court has held
there is a suit. May submit. May I submit?
Division bench of this honorable court, my lord, please have a look at, my lord, one judgment for my lord's consideration. Please come to, my lord, page 5. At the bottom, my lords, get the pages. AR, my lord, 1995, Karnataka, 35. Bottom, my lords, get the page numbers 5. Please look at the second column. Last, my lord, 7 lines. Moreover, there is no evidence to show that the ancestral properties were blended with these properties so as to impress it with the character of ancestral properties. In view of these circumstances, these properties cannot be held to be ancestral properties. Then, my lord, please come to the second column of the same page. My lords may come to, my lord, second unnumbered paragraph. 1, 2, 3, 4, 5, 6 lines from the top. Merely because respondent number 2 has joined in the execution. Sorry, when a sale, my lord, third line, when a sale is to take place, sometimes the purchaser by way of abundant caution makes other close relations like son, etc. to join in that sale deed. Merely because respondent 2 has joined in the execution of exhibit P1 and P4, it cannot be said that the properties are the ancestral properties. Anyway, my lord, this is what it is. And there is no counterclaim by them.
So you are challenging that agreement, sharing agreement?
My lord, I am not challenging the agreement. What I am submitting before my lords is, it must be given to me. I will not do one thing, subject to my being corrected by your lordships. I will not, my lord, alienate 2/3, my lord, of the plan, this thing, my lord. I will keep it myself. I will not, my lord, in any way, my manner, my lord, alienate it. I am also getting old, my lord. I require, my lord, medical attention. These people have thrown, my wife has thrown me out of the house. This is my problem. And, my lord, my own property, I given it for development. He has, my lord, builder, my lord, this is like, my lord, the story of the monkey and the cat and the 2 monkeys.
My
My
lord, the
problem
facts
is
are
that-
otherwise, my lords.
Is
My lords.
agricultural land?
No, my lord. This is now, my lord, it is built, my lord. Flats have come up. my lord.
Flats, my lords. It's an
Flats have come up.
Now it's an apartment.
Apartments, my lord.
House is constructed.
Yes, my lord.
It's an constructed apartment, my lords. Lords, there is a suit, my lords, which is pending before the civil court, my lords, in OS number 540 of 2019, my lords. There where we have to declare whether who is the owner and other things, my lords. This is a suit for mandatory injunction, my lords, where there is a scope for to look into as to who is the owner of the property, my lords. The entire suit is relying upon the joint development agreement. Joint development agreement, owners refer to, or, my lords, the owners, my lords, the appellant herein and the respondent number 2 and 3 jointly. But owners constructed area means the owners constructed area means the constructed area of the appellant and respondent number 2 and 3 jointly, my lords.
Any other suit is pending?
There is a consultant suit for partition, my lords. It's pending between the appellant herein and respondent number 2 and
Okay.
3.
There's no, sorry.
So you want to use the property?
Please, my lord.
You want to use the property?
Lord, naturally, my lord. I am old. I have to at least reside somewhere. They throw me out of the house. One. Secondly, I also require some funds. What I would suggest is, my lord, if the entire, my lord, the builder has to come before your lordships. If he hands it over to me, I am, my lord, willing to, my lord, give that undertaking to your lords. Is that 2/3, my lord, I'll retain it as it is.
Number 1 is builder.
Yes, my lord.
You are representing.
No, I'm not the builder, my lords. I'm the wife and husband of the, wife and son of the appellant herein.
Please issue notice and put.
Please, my lord, please, my lord.
My lord, the facts are otherwise, my lords. The appellant herein is not addicted to all bad vices, my lords. He wants
In
to,
any case, your maximum share is 2/3.
yes, my lords.
Even if you go by your case.
Yes, my lords.
So then why should the entire property be blocked?
No, it is not blocked, my lords. The builder has already handed over 1/3 to them, my lords.
Yelli.
It is there.
Let him
It is
hand
there.
over, my lord, 1/3 to.
No objection, my lords. If the 1/3 of the share is handed
well,
over
my
to the appellant, we have no objection.
Direct, my lord, emergent notice. I'll take it.
We have no objection, my lords. 2/3, let it be handed over to the,
Divisible.
Yeah, of course, my lords, it is.
My lord,
it's
what
a
has happened
flats,
is
my lords,
there are
inside
flats, there are flats, my lord.
How would you, how would you divide 2/3?
My lord, that is, my lord, not one flat. There are, my lord, number of
Multiple
flats.
flats, my lords.
82
multiple-
flats are there.
74 and odd, flats, my lords.
Correct, but how will you divide?
But there are 30 flats which just come to the owner's share, my lords. In that, 10 share, 10 flats to
10,
the.
my lord, I can take it.
Yes, my lords.
20, I'll
Objection.
retain
We
it
have
as
no
it is.
objection, my lords.
All right.
20, let it be with respond number 2 and 3.
So if something is worked out, then entire appeal will.
I know, but that's why I said, if your lordships can direct, my lord, emergent notice to the builder, we'll try and see.
It has
what-
gone to the extent of, my lords, settlement, but at the end, my lords, they turned
right.
back, my lords.
Whether, my lord, I turn, they turn, we'll see, my lord.
The honors partition suit is there or honor, the title suit is there
The suit for partition
Partitions.
is pending.
by you?
Yes, my lords. By the
No
wife
interim order.
and
What is
son
it? What-
against the
what was this
appellant
suit?
number 1.
This suit was for what?
This was for mandatory injunction. This suit was only for mandatory injunction, seeking a direction to hand over the possession, my lords. I mean, of the owner's
The-
concerted area
to the
from the
plain-
builder.
To the plaintiff alone.
Yes, there, the trial
can't
court
be
cannot
that.
look into, my lords, as to who is the owner of the property.
Correct, Mr. Holla, this prayer could have been made in that suit also.
Yes,
My lord, I'm the absolute owner of the property. There's undoubtedly, my lord, please look at, that's why I said. It was my father's sole property. There was a partition between me and my siblings. I got, my lord, this property. Merely because I put their name, it doesn't get, my lord, don't get any right. Therefore, they don't file, my lord, I can understand. They did not, when they filed a written statement, they don't file, my lord, a counterclaim. Please look at that. Therefore, the trial court should have granted, my lord, the decree in its entirety in my favor. My prayer was, hand it over to me, because I'm the absolute owner. That is not looked into.
My
That's
lords,
all, my lord.
except making the parties, my lords, the respond number 2 and 3. There is no prior sought against them in the suit, first and foremost. Second thing, my lords, facts are otherwise, my lords. My lords, even before entering to joint development agreement, my lords, the appellant himself, my lords, he was about to dispose of the property, my lords, with the help of the, respond number 2's, my lords, father, and by pledging her jewelries, my lords, she has saved the properties, my lords. All those things will be dealt before the trial court in a suit for partition, my lords.
No interim,
Mandatory suit, my lords, how can they seek for the ownership, my lords?
there is no interim order in the partition suit.
Oh, What one,
They
what,
sought,
what,
nothing
what,
was
I
given to
don't
them.
know, what interim order, my lords? We have not sought for any interim order. We want
That's right. Absolutely.
partition of the property, my lords.
Senior Advocate Mr. Holla for the applicant. This is an application for appeal. Appellant, original plaintiff. And learned advocate Mr.
Hemant Kumar,
Hemant Kumar, respond 2 and 3.
2 months.
2,
Caveat or caveat.
not 3.
Not 3 I have not filed, my lords. I'll undertake to file Wakalat on behalf. Respond number 3 as.
Who appeared on caveat. Notice returnable on. We keep it on 17th of December.
As your lordship, please.
The appellant shall serve the respond number 1 and 3 before the next date. You are filing well now.
My lords,
You are filing well now. Appellant shall serve respond number 1. Full stop. As far as respond 3 is concerned, learn a record, Mr.
You may slow.
Undertakes to file Wakala now before next date, stating that he would be, stating that he appears, however, yet to file the Wakala now. Full stop. It is observed that on the next date of posting of the appeal, the court may take up the appeal for final disposal.
Please.
Subject to the submissions of the parties and convenience of the court.
Please, please. ma'am.
To be
Great.
listed at, to be listed at 2:30. So something is being worked out in our mind. If you agree, then
Please.
yes, yes,
we'll dispose of so that.
yes, ma'am. Best.
Will ultimately be. He will be tempted.
Bill number 24, Mr. Sanjeev BL, 24.
Against the order, my lord, pension has been settled. This honorable court was pleased on 25/7 to pay the interest part. It has not yet been paid.
Lord, government has passed an order, my lord. Communication has been sent to the treasury to make the amount has been determined, my lord. Interest is payable between July 23
Shall we keep
and
it
March
pending or-
24.
Shall we keep it pending or disposal?
I leave it to my lord.
Sir,
Something is there, then we can dispose of.
There is a communication issued to the treasury, my lord. The pension amount has been remitted. Now it's the interest component, my lord.
Pension has been paid.
Determined as 1,77,922 for the period between 11th
Direction.
July 23 and 31st March
In the
24.
order of learned single judge. Dated. Direction in the order passed by the coordinate bench. Dated 8th August 22 is to direct the authorities to regularize the services of the respondent as petitioner hearing and to settle the entire pension and other related benefits within stipulated time with 18% interest. Also, when the contempt process, when the present contempt petition regarding alleged non-compliance of the above direction come up for consideration, learned counsels are ready that the pension is already settled.
Pension is settled.
Pension amount and
Pension is
related
settled.
benefits are already settled and paid to the complainant.
Please.
The only aspect of compliance is the payment of interest
On
which is
delayed payment.
contemplated in the directions of learned single judge. Paragraph. In the above regard, learned additional government advocate with Harish produced copy of the order dated 26/9/24, which is in vernacular and explained to the court to be a letter to the treasury officer addressed by
The principal secretary of the education department to the treasury, my lord.
secretary to the education department.
Department to the
Whereby
treasury, my lord.
treasury officer is instructed to calculate and pay the interest to the petitioner. Full stop. In view of above, the aspect of payment of interest is also taken care of. Full stop. Observing that the interest shall be, in payment of interest shall be acted upon and shall be paid to the petitioner within a period of 6 weeks.
Yes, my lord.
From today,
Communication
the
has been sent. to the
Present
treasury.
contempt proceedings are closed.
Public.
The above communication dated 26/9/24 shall remain on record.
Please.
Seal number 25, to Siddhayal.
So in this matter, my lords, the learned single judge's order has been stayed by this honorable court.
Stays
my-
there, Your Honor. I'm filing in a memo of this along with.
The order is stayed.
Steve.
The question is, my lord, I am the complainant.
Stay copy along. On 14th November, it's been stayed.
So it is stayed.
I am the complainant, my lord. The order passed by the learned single judge is at page number 17. May kindly be seen. Or else I shall
That
read.
order is stayed by us.
Yes.
In my absence, it has been stayed, my lord,
That is a different thing.
because the order,
That is you contend in the appeal.
kindly see, whenever only payment of my salary, I am jobless is past more than 5.5 years.
It can't, nothing can be done.
Despite of the court order, they have
The order
not
which is
taken me
subject
for
matter of-
duty.
There is no gainsaying. There is no denial that the order which is subject matter of contempt proceedings herein has been stayed. The division bench, as per order dated
That ex parte interior matter may kindly be.
14/11.
14/11,
11.
before passed in writ appeal number 0842 of 24. In that view, the contempt proceeding does not survive presently. Also, the party shall abide by the outcome of the appeal.
Obliged. Much of.
Petition is disposed of accordingly.
Alas, my point is,
Nothing can be done now. It is stayed, is stayed. We can't reopen. the-
Earlier date may kindly be given. Earlier date.
No date, so you abide, both will abide by the outcome of the application.
Seal number 26. BV Mallar Reddy.
My lords, appearing for respondent number 5 in this matter, my lords. May I request leave to file objections to IAS number 2 and 3 of 24, my lords.
My lords, I appear for respondent number 6.
What is it about? 2017 PA.
My lords,
I have filed IA1 and IA2 of 2024, please, my lord. IA1 of 2024 is for impleading additional respondents as respondent number 7 and 8, please, my lord. IA2 is for a direction, please, my lord. IA number 3 is filed by me, pleading application. We include 6 to 9 as petitioners. Additional.
Nothing should survive now because of your affidavit. The reply is there or no?
My lord, it is for. My lord, we haven't filed a reply, my
First
lord, it is for
respondent
the
filed.
VDA.
First respondent filed the objections.
My lords,
That we have already once, we have
Common
removed the.
objections to the application.
Yeah.
This is review record.
Page
A
100.
public road is being occupied by respondent number 4, 5 and 6, please, my lord, regularly, and they have been preventing the public from using the road, please, my lord. The recent photographs also have been filed along with application IA number 2 of 2004, please, my lord. Your lordship is, kindly will look into this recent photographs, please, my lord. They have been causing the hindrance and obstacles for using the public road by the public, please, my lord. Especially these proposed respondent number 7 and 8, please, my lord. Therefore, I would like to implead the present proposed respondents, please, my lord. That application is IA1 of 2024. The notices may have to be issued to these respondents, please, my lord. The another prayer, additional prayer I have sought in IA number 2, please, my lord, to prevent the frequent illegal obstructions that are being caused by the respondent number 4 to 6. Another is to initiate criminal proceedings against the obstructors, please, my lord. Respondent number 6 is claiming that theirs is a gated community in spite of releasing the road to public, this BDA, please, my lord. Earlier, there were orders, please, my lord. There is on June 2, 2017, there was an order, please, my lord. Subsequent to on 30th August 2017 also, there was an order, please, my lord. No private person can be permitted to erect any compound gate or gates or security bank bunkers or checkpoints.
Now barricades are removed, everything is.
Your Lordship may kindly see the photographs, please, my lord. I have filed along with IA number
My lord,
2.
the first respondent filed the objection. It is under page 113, my lord. It starts from the 113.
We are on that only, one.
My lord, once we have removed the obstruction, my lord. Now their complaint is that, my lord, once again, the fourth and fifth respondent, they once again erected the barricade.
Who is it?
The respondent four and five.
Six.
That is false. That is false, my lords. We're not in possession.
Lords,
Then you remove again 5 and 6. Who has erected the barricades?
My lords,
Five and six.
Remove them.
No, I am for the first respondent, my lord. First respondent.
Second,
This one you are supposed to remove.
My lord, once we removed, my lord, once again they erected again.
Once again you remove.
my lords, that is a false.
Let them to direct the fourth and fifth respondent to, my lord, if we removed once again, they once again put up the barricade.
Why should we direct? You remove.
my lords, I appear for respondent number 6. My lords, I appear for respondent number 6 in this matter. My lords, the submission is false. The barricades are not put up again. My lords, I may be given time to file my objections to IA number 2, my lords.
So you remove the barricade.
My lords, the barricades are not put up, my lords. Our instructions are that,
We send a team of lawyers to inspect.
my lords, the compliance report,
For imputing the breaching the direction.
my lords, the compliance report was filed. My lords, the compliance report was filed in terms of the interim order, my lords, passed. And my lords, the compliance report was taken on record by this honorable court.
What are the barricades?
They are blocking the main road, my lord.
Why?
They are saying that the entire layout is the gated community.
no, it is
There is
running
no such
through,
concept of the gated
it is
community.
running through a layout, please, my lord. They say that theirs is a gated community. In spite of relinquishing all the rights in respect of these roads in favor of BDA. There is no concept as gated community as held by this division bench of this honorable court very recently.
Your lordship may kindly take the photographs produced along with the compliance affidavit, my lords, dated 12/9/2017.
Your video.
Yes.
Barricade.
My lords, my instructions are, my lord, that barricades have not been put up again. My lords, the compliance report was filed, my lords, by the BDA themselves. My lord, saying that the barricades have been removed and that compliance report was accepted.
PDA itself says that barricades are again.
Please, my lords.
PDA itself says that barricades are again put up.
My lords, which is why I may be given an opportunity to file objections to this application. And my lords, a hearing may take place, my lords, and then the matter can be decided. My lords, moreover, my lords, I have filed my objections as on behalf of R6. My lord, the petitioners are private parties who own lands, my lords, in and around the apartment complex. And my lord, this is in the nature of a public interest litigation they have filed, my lords. My lords, we have preliminary objections to the maintainability of the writ petition itself. My lords, be that as it may, I may be given an opportunity to file objections to IA number 2 of 24, my lords.
File.
Please, my lord.
What you are doing since 2017?
My lords, in 2017, an order was passed to remove the barricades. My lords, the BDA under their supervision, my lord, the barricades were removed and a compliance report was filed in 2018.
We are only going to verify the factum whether you put up or not.
My lords, I may file objections, my lords.
But that will not prevent us from passing the order we want to pass. So come at 2:30, all of you. We'll pass the order. Are you saying that it is?
No, that is the complaint of the petitioner in the IA, my lord. We have removed the,
Don't make irresponsible statements.
no, I said, my lord, it was removed. Now they filed the application complaining once again, the respondents have erected. They have filed the application, copy was served to me.
The photographs may kindly
is
be
why I
produced,
submitted.
Registrar, along
First
with
respondent
newspaper.
conducted spot inspection on
Yes,
18
by that time, we have removed, my lord,
its
entire.
officer and found that the road was blocked
Yes,
within the barricade. The officers who conducted the spot inspection called upon 6 respondents to remove the said barricades and allow the public to use the said public way without any restriction.
yes, my lord. 2017, we have removed the entire things, my lord. Entire,
My lords, the order of 27th February 2018 may be seen, my lords, in that a compliance report was filed and that compliance report was taken on record by this honorable court. My lords, 6 years later, this application is being filed again to say that barricades are put up.
Please, Miller.
You file an application.
Yes, please, Miller. Your lordship may kindly see.
Who are you? Petitioner.
Petitioners, please, Miller. With photograph of the paper.
Which order?
Regularly, regularly.
Lords,
they have
order
been
dated
meddling, please,
27th
Miller.
February 2018 of this honorable court, my lords,
27th February
of 2018, my lords.
18.
Paragraph 2, my lords, of that order. It is noticed from the record that the Bangalore Development Authority reported compliance of the said orders. And after recording compliance, the said bench ordered the matter to be posted for hearing in the usual course. So, my lords, a compliance report was filed, my lords, by the VDA. This application, my lords, making the allegations have been filed subsequent to, my lords, this compliance. Which is why I'm seeking, my lords, time to file objections to the application, my lords.
Where is the application?
My lords, it was served to me on 30th.
Application is A number 2 of 2024, please, Miller. Filed on 28th November.
Latest application. That's me. Two of.
Respondent number 2 and 3 being the police officers, please, Miller. They are not taking any action actually to prevent this, please, Miller.
Who is number 6?
My lords, I appear for respondent number 6.
We know that. Who is number 6?
My lords, Apartment Welfare Owners Association of Prestige Shantiniketan, which is the apartment complex, my lords, adjoining the private lands of the petitioners, my lord.
This is a public road.
Public road,
Yes,
please, my
public.
lord.
My lords,
The
It is a Kachcha.
developer, the owner and developers have relinquished all their rights in respect of the public parks,
That we
public
have,
roads.
we have noticed by virtue of some deed.
Yes, relinquishment deed. That also has been produced, please, my lord.
And this Kachcha road is also public road.
Kacha Road is, that is a continuation, please, my lord.
And,
Page 25 is the relinquishment deed, please, my lord.
because they will remove. In this public interest petition, which was filed as back as in 2017, the grievance and the prayer was in respect of putting up of illegal structures, compound wall, barricades in the 80 feet Bangalore Development Authority Road from a public park area, etc. by the private respondents. Full stop. The direction was sought against respondent 1 to 3 authority to clear the said illegal erections, encroachments, etc. Illegal erections, encroachments, barricades, etc. From the affidavit filed by respondent 1, Bangalore Development Authority. It inter-alia transpires that at one stage in the year, at one stage in the year
2014, please.
2017, spot inspection was undertaken by the officers of the BDA, integrated BDA, BDA, and the barricades which were put up by responder 6 herein were removed. Full stop. The petition has been remained pending. Petition has remained pending since all the years. The petitioner's applicants have filed interim application number 2 of 24, in which, for the detailed reasons stated therein, it is a grievance raised along with the depiction in the photographs produced that the barricades are again put up to block the free passage of the road, which is claimed to be a public road and public amenity. It is the case that it is respondent 6 who is instrumental and responsible in placing the barricades and blocking the road. If the public property paragraph is encroached upon, obstructed, or blocked in any manner whatsoever, and the use by public of the public road is prevented, it is a matter of serious public concern. In the facts and circumstances case, the court, in the facts and circumstances case, it is to be observed that Bangalore Mahanagarpalika is also a necessary party, so that its stand and role in the controversy would be ascertained by the court. At this stage, learned advocate for the petitioner, Mr. So-and-so, seeks permission to add BBMP as party of the respondent. Also, there shall be notice to newly added party returnable on 10th of 11th of December. Notice through hand delivery, by hand delivery is permitted. In addition to the notice permitted as above, learned advocate for the petitioner shall furnish a copy of the petition and the present application to learned counsel who normally appears for BBMP in this court, who shall appear on the next date to assist the court. Paragraph. As learned advocate, Mr.
Pradyumna, my lord. Pradyumna.
So-and-so, for respondent 6 wants time to file reply.
Objection.
He may file reply before the next date.
Please.
A number 3 may be.
Put up.
IA number 3 for including application.
Who are you? Who are you?
I'm supporting the petitioners.
Who are you?
I'm aiding the petitioners. I'm the residents of that area. For my ingress and egress, the roads are blocked.
IA number 3 of this IA is filed by the
Huh.
residents of the area.
Yes.
My lord, I appear for respondent number 5.
This is because
I have series of
observing that the audience will be given to the applicant in course of the hearing, during the hearing of the matter.
Great, sir.
IA number 1,
bar 2.
Where will find
Please, my lords.
description of,
Description,
30
page
gutas,
number
92.
34.
Yes. Then
In all total, my lords, this is
15
1 acre,
gutas,
15 gutas.
97 too.
Yes, my lords.
And third is 31 gutas.
31 guntas in survey number 97 bar 3.
97. Now what is the position now?
Subsequently, my lords, all the revenue records, everything has been changed. All the revenue records, the RTCs, Pandis and all have been changed to the name of the school, my lords. School is in the possession of the property. Now what has happened, my lords, in the year 2012, the respondent number 3 and 4, who claims to be a class 2 legal heirs of this Pattabhirama Rao, they execute a sale deed in favor of the respondent number 5.
Instituted?
They institute a sale deed with respect to survey number 97 bar 3, 30 guntas.
97.
97 bar 3, 30 guntas extent, my lords.
So,
The respondent number 3 and 4, they execute sale deed on 7/4/2012.
so what is the public interest in this?
Now, my lords, my prayer is, my lords, for the government and the second respondent school to safeguard the property of the school. We are the villagers of the.
Sale deed is between whom?
Sale deed is between the third respondent, fourth respondent will execute it in between to the fifth respondent. Subsequently, the fifth respondent will execute 15 guntas of sale deed to the sixth respondent. The fifth.
The land is with educational institution.
Yes, my lords. We are the villagers. So in 1956 itself,
Then that institution is not coming for.
institution, my lords, in fact, we made
Coming
representatives.
forward.
Institution has to come forward, but we are the villagers of the petitioners are the villagers. Our intention is only to safeguard the school property, my lords, not any third person to come and
Respond number
encroach the
516.
property.
Respond number 516, ma'am. I'm the purchaser of the property. Yes, ma'am. One small submission. Before the filing of the,
Respondents 1 and 2.
before filing of the writ petition, my lord, they already civil suit adjudicated before the competent civil court subject matter of the property.
My lord,
Institution is a party?
Please. Yes, my lords. The second respondent is the government primary high school.
Then you have to take your stand. What is about the controversy? We don't know what order we can pass in this verse. You have to take a stand at least.
that I'll do, my lord. I'll do.
May make submission. Now, already last at having submitted that. The very same subject matter adjudicated before the civil court. Now the civil court decreed in favor of the respondent number 5 and 6. Now the petition number 3 is one of the witness who is supporting the defendants in the said suit. Now he filed the affidavit. Kindly peruse the affidavit in page number, my objection statement, page number 190, please. He himself is deposed before the civil court and supported the defendant, stating that this land has been utilized by the respondent number 5 and 6 and also defendant constructing the house in the said property. Now when they've defeated, and also the petition number 1 is none other than son of Krishnappa. There was a complaint against father. The respondent number 5 filed the complaint against his father in the year 2017. This is a personal vengeance between the parties. They have colored as a PL. Now already say subject matter of civil court is adjudicated against that RA filed. RA is pending before the appellant court. Why suppress these facts? They have filed the writ petition. Even very same set of facts been adjudicated by the civil court. They decreed in favor of the respondent number 5 and 6.
You filed the evidence?
Yes, my lord.
Very-
Kindly peruse the page number 51, please. Annexure G.
Of your reply.
Yes, my. Along with my objection statement.
Statement of objections.
Yes, my.
By 5 and 6.
Annexure G, my.
So read, what is it about?
Yes. The respondent number 5 and 6 are plaintiffs in OS number 163 of 2015.
Who has filed the suit?
Respondent number 5 and 6.
You.
Yes, my.
So that is 163 of 15.
Yes, my.
What is that suit?
Declaration.
Declaration.
Suit for declaration and recovery of the possession. The respondent number 1, defendant number 1 to 8 are encroachers of the said property.
Where number 2 is a party.
Yes, ma'am.
Number 2 herein is a party. Where is the plaint? Plaint is there.
Yes, plain.
Yes, page, annexure H.
Yes,
No,
plain time not annexed.
it is not annexed.
Yes,
It is appeal.
yes, there is appeal.
So where is the plaint?
Plain not annexed, man.
Not annexed.
Plain not annexed. The judgment and decree has been put.
Judgment and decree is annexed.
Yes. Now in page number regarding the,
Page 351.
yes,
Correct. Then what can be done? Mr. Suit is there. We will not entertain.
suit for declaration in possession.
So who are the defendants? There?
If I may be permitted, my lords. This is the land gifted
The
to
first petitioner is none other than relative of defendant number 6 in OS number 163 of 2015. Man.
The land, my lords, is gifted to the government in the year 1956. The government is not a party to the proceedings.
your-
We have not been made parties, my lord. I am taken by surprise with this decretal of the suit, my lord, the RA that is filed.
You are not a
They
party.
were, no, they were conscious that the government primary school was being run. But for reasons best known, my lord, they have not been made as a party. And even in the appeal,
So gift is in favor of the government.
yes,
Yes, my lords.
to run an educational institution.
Annexure A is my gift deed. That was in the year 1956 itself, my lords.
You go through page 107, 109 to 111 of the judgment.
Yes. Regarding the gift deed is concerned, there is a finding in
This is
civil
the
court
gift
number
deed
1.
has not been acted upon. My lord, that, they say the gift deed, according to, my lord, the respondents, respondent number 5, the gift deed has not been acted upon.
That is not believed by the civil.
Yes, I have to get instructions, my lord,
Taken.
because I wouldn't know what to do.
Taken.
Now, kindly vacate the interim order, please, because the nature of the interim order, please, nature of the interim order, I am in possession of the property and the access has been restrained, my lord.
Yeah, interim
But
order.
consciously, we have not been made parties when they knew that we were running the school.
Now they have appeared.
Behind our back, they come and now they say that, my lord, by virtue of
No.
the decretal of the suit, they should be allowed to be in possession.
Kindly permit the order which interim order passed by this honorable court, nature of order, my lord. As an interim relief, it is prayed to restrain the respondent number 516 not to interfere. Now the house has been constructed in the very same land and I am residing in the very same land, but my movement has been restrained, my lord. The nature of injunction. Second one thing is that the petition number 1 misused the interim order, my lord.
We will dispose of after Ms. Akbar takes instruction. 17th week.
My lord, some more time, my lord, because I'll have to interact with the education department. After vacation, if my lord could have it, I would be obliged.
You try up to 18th.
Very
We'll give time if you need 18th at 2:30.
Please, my lords.
Old matter, no, 20. Anyway. Since learned additional government advocate, Ms. Neelofar Akbar is requested to take instructions and apprise the court about the stand of Dispute 1 and 2 in relation to controversy, to be listed at 2:30 on 18th of December.
Please, my lord.
So number 28, Sundaresh. On filing.
My lords, I appear for accused in this case, my lords. After obtaining NOC, we have come for the first time, my lords. Affidavit is ready, translation has to be done, my lords. I seek for a week's time, my lords.
After it,
Date may be given. Otherwise,
20th January.
Grateful, my lords.
Number 29. Sharon Govind.
Yes, your lordship.
You change your sides?
I'm for the accused, your lordship. Your lordship, I have one submission to make in this matter, your lordship. As per your lordship's order dated 21/10/2024, there was a specific directions with regard to reimbursement of the school fees of the child, your lordship. And even in the decree passed by the trial court, there's an observation made saying that the husband is willing to pay or incur the school expenses of the child. And in para 9 of your lordship's order on 21/10/24, it reads that an affidavit with respect to the payment of fees should be filed before this court, which has not been complied with, your lordship. 2 terms fees has not been complied with for the year for 2000 for year 2 and year 3 of the child, your lordship, grade 2 and grade 3. All in all, it's accumulation of 3 lakhs that has to be paid by the father to the child, your lordship, which he's undertaken to pay.
Your mother
I'm for the mother. I'm for the accused mother. Yes, please, your lordship.
accused.
Yes.
I've been instructed that my client's salary is cut by 70%.
That is no ground.
No, I'll state the same on oath. I was required to file an affidavit. I will state the same on oath.
Yes.
Your lordship, if I may, there's a specific direction from the trial court that the fee will be paid on 4 terms, your lordship, 4 installments in a year.
So you are meeting at this mall?
We've met at the mall, your lordship. That is
When? Lastly when?
last, on Friday, I think
25th of October, just once. Even though I had
Please.
weekly visitation, I've been having no access to my.
No, you come with the amount. Otherwise, you come with the amount of educational expenses. For the academic year, quarterly installment, what is not paying,
He's not paying the school fees, your lordship.
Pardon?
School fees that was directed by this lordship for the
So where
defendant.
is you have paid it?
No, I am to I've paid the school fees for the child.
You already paid.
I've paid.
Where is the amount and receipt, etc.?
I'll produce it before the next date, your lordship, please.
Produce it.
Current term, in fact, I had.
You
sent
convey by a letter with a copy of the receipt that this is
Please.
amount is payable.
Please, your lordship,
In the meantime,
please, we've also communicated by email that we've paid for this term. The wife has already communicated to the husband via email saying that I've paid for grade 3. You
You-
reimburse the amount back to me.
and already sent it.
Yes, email is sent.
To place.
I'll produce it,
Place
please.
on record the copy.
Please.
Current term.
What is the amount paid?
Your lordship, for currently the amount is 1,91,000 to be paid.
1,91,000.
1,91,550 for the current year. For the previous year, for grade 2, second standard, that is 1,71,720 that needs to be paid, which needs to be reimbursed.
No, which is the amount to be reimbursed?
Both the amounts, your lordship, both the amounts. So in total, it's 3 odd lakhs, your lordship.
The current term, in fact, my lord, I had.
A
sent-
proposed order dated, a proposed order dated 21/10/24 passed by the court. When the contempt proceedings come up for today for further consideration, learned advocate, Miss, what is your name?
Please, my name is Adya, your lordship.
So and so, submitted that the fees for the academic year 23-24,
23-24, please, your lordship.
23-24,
22-23 and 23-24, 2 terms.
22-23 and academic year 23-24 to the tune of that the educational fees for the education of daughter Amara MAARAH to the tune of rupees 1,91,550 and rupees 1,71,720 for the academic year 2023, 22-23
Please,
and academic year 2023-24
please,
respectively has already been paid by the mother.
please.
It was further submitted with reference to the observations and directions of the past in the aforesaid order dated 21-10-24 that it is that it is incumbent on part of the applicant father to reimburse the said amount. It was further submitted that after payment of the amount as above, a email communication was addressed to the applicant father requesting him to reimburse. However, the father has not paid any amount so far. Full stop. Prima facie, this conduct amounts to aggravated conduct, amounts to contempt on part of the father. Full stop. What is it, sir?
I will file my affidavit on the next.
No affidavit. What affidavit?
The court has directed me to file an affidavit. I may be permitted.
No, we are not permitting affidavit in this regard.
Multiple occasions have
It is
also
there.
gone by, Your Lordship.
The rest of the directions, including the undertaking by the petitioner for reimbursement of daughter's Amara's education expenses for the year 23-24 in 4 quarterly installments shall be continued to cooperate.
I'll instruct my client to, so may this be taken up in the coming week, my lord? Any day in the coming week, I will have a word with my client and submit
Monday.
the body. Any day in the coming.
Monday,
Please,
to be listed at 2:30,
if I may request for Tuesday, my lord, Monday, at some information.
Tuesday at 2:30. Full stop. On that day, it is expected that the applicant father shall come with amount to be reimbursed towards the expenses of fees as above, failing which, the father may be exposed to, applicant may be exposed to contempt of the court.
Request for the email to be resent, my lord. I'm unaware of.
No, why? Now you are known in the public proceedings of court. You are
Introduce-
given to understand that the amount is paid. And we rely on that you got the receipt also.
Please, I will produce it by the next date of hearing, please. Grateful.
My lordship direct to produce the, my lordship, last time this court has direct to produce a 248 notice, my lordship. Now I am producing a new 248 notice, my lordship.
Lord, I had already produced on page number 18 to 24.
My lordship, last time directed to the produce the 248 notice, my lordship. I produced the documents, my lordship.
So what is the contempt for?
My lordship, their contention that my lordship complaint is alleged that my lordship to not to demolish the said building, my lordship. My lordship, this court has already granted the stay order, my lordship, not to demolish until decide of the writ petition, my lordship. The building owner has approached before this court, my lordship. This court already granted the stay order, my lordship, not to demolish the building, my lordship. There is a stay order in the copy in the page number 6, my lordship. This court has directed already not to demolish the building, my lordship.
The order under
My lordship,
CH-1.
yes, my lordship.
3.
No, they approached from the, before the chief commissioner, my lordship, appeal, my lordship. After
But I
dismiss the appeal, they approached from this court. This court has granted the stay,
This order is,
Already
appeal order, my lordship.
The
this
petitioner.
order you are,
The
one
petitioner,
second.
please.
This order you are producing is under section 248(1) or
2
248?
parted 1 and 3, my lordship. 1 and 2, 3 and 356 also, my lordship.
3.
3 also, my lordship.
3 or 1?
2 parted 1, 2 and 3 also, my lordship.
3.
Yes, my lordship.
Here, 3.
And also 356 also you already passed, my lordship, demolition order also.
Order of, is the order of demolition. Provisional order was passed. No ground to drop the provisional order. To demolish, confirm the order of demolition. So now
Already-
it is,
Like to submit,
In this regard, my lordship, already this court has granted stay order, my lordship. The writ petition, my lordship.
now this is state.
Yes, my lordship.
Order of chief commissioner was stayed, my lord. order passed by the
Things
chief
are well-
commissioner. My lord, this is sought action against me.
Because order was not executed and the contemptor has not valued the order. He has disobeyed the order. And after I file my contempt case, these people come and file a condonation application with the single bench judge. My lord, I would like to draw your attention to my petition, my lord. The 196, which my learned counsel is talking. May please see page number 44 onwards. My lord, the petition, what my learned counsel BBMP is asking for stay is for the same petition which I have already submitted over here and with a detailed arguments which I have myself proved to the commissionerate court that how illegal building was constructed and how the sanction plan was taken illegally by showing somebody's land. And the same thing they are coming and showing up under the same court, my lord, in the single bench. My application is for contempt at court, and I request my lord to hear my prayer.
What do you say?
My lordship, already this court has granted stay, my lordship. After vacating the stay, we'll demolish, my lordship. This court already granted stay, my lordship. After vacating the stay, we'll demolish it, my lordship.
Check the direct,
My lordship,
check the direction.
the trial court,
Which are the directions under contempt?
contempt or not to stop the construction, that is only, my lordship.
Read it. Read it.
They stop the construction to implement the order, my lordship.
Read it.
Since the grievance of petition has been addressed to passing the order under section 248(1) of BBMP Act, the matter is pending appeal and the petition disposed of placing government of the parties under guard. Needless to say, once an order under section,
Slowly. So that not only you, but we also understand.
yes, my lordship. Needless to say, once an order under section 248(3) of the BBMP Act has been passed, respondent number 1 is not entitled to carry out any construction. Respondent resigning from the doing so, respondent 3 are directed to implement the order. That is the order, my lordship, single judge, my lordship.
So you are directed to implement this order.
Already, yes, my lordship, that is the order.
But it is state.
Yes, my lordship.
In which petition?
Request the stay to be removed, my lord.
In which petition it is state?
Stay, my lordship, in the 2011-2024, my lordship.
2011, read petition 2011.
The writ petition number 26271-2022, I'll place the already record.
Slowly, 26,
26271-2024, my lordship.
6270,
24, my lordship.
2024.
Yes, my lordship. The order date is
Order dated
2011-2024, my lordship. The page number 6, my
12,
lordship.
11, 20. So then what? Oh, you are for?
My lord,
Sought action against me. He sought action against me.
because it's not party over here.
Will hear. What you are for?
She sought action against me, my lord.
Pardon?
She sought action against me, my lord. She is not made as a party to proceedings before this court.
Honorable.
Please.
My
But
lord,
you are the petitioner in this.
Petitioner in that order.
done by the BPSC, the respondent, the accused. So I have approached this court because the clear High Court order, honorable order was on the respondent. Based on that, I have come to this court and this honorable court may please permit my application and also give stay order for whatever they are talking about. Because these people did not give me the notice, and when I happened to see online, I went in front of the court and I requested them that I will produce the document, which I will do subsequently. But I request the court to see this as a contempt of the case, and also if they are trying to link, then I want that order to be removed as a stay. Because all the documents, my lord, please read page 47, my lord, which clearly says, my lord, a documentation is being done after a length of around 1.5 hour of my arguments with the BBMP commissioner, which I have established the fact that the sanction plan was not taken. And BBMP has inspected the premises way back in 21, my lord, which is already there in the provisional order. They have given 1/7/21, my lord. The page, I just referred to the page, my lord. So it is only, they are playing the game of tactics, using the court's time and then just wasting of time. And this does not, it is not giving me solution, my lord. I have been fighting from 2001 till now, all alone, my lord.
That is all. Anything you have to submit?
Please, my lord, view of the layout plan, my lord, the original owner.
Substantially, that on page 41 will give answer.
In fact, my lord, this petitioner was purchased the site number 8, my lord. Site number 8, my lord. Thereafter, my lord, she occupied the site number 10, my lord. This is, she was in possession of the site number 10 now. Now, the BBMP has assigned and the new number in view of the other person was occupied this site number, my lord. The BBMP has assigned site number 9A to my property. They confirmed the kata and they have issued the plan sanction to me, my lord, for construction of the building. She has not at all obtained any sanction plan. She constructed the building. She sought action against me, my lord. She is in occupation of site number 10, my lord. Even she purchased the site number 8. She is in site number 10.
What he is showing is not there in the BBMP at all because that is not being registered.
This is not approved layout, my lord. Even otherwise, my lord, as per the original owner, my lord, he formed the layout. This is the site number. She is in possession of site number 10. BBMP has assigned me site number 9A. They have issued the kata in respect of site number 9A, my lord. Kindly see this kata certificate, my lord. They have issued the sanction plan also, my lord. As per that sanction plan, my lord, I constructing the building. Not a peg. Let them ascertain, my lord. BBMP persons is there.
The 41 which BBMP Commissionerate appeal has gone into the detail, called all the 3 departments, my lord.
You are party to that writ petition or not?
Yes, my
Yes,
lord. She is also party.
She is a
in the-
party.
She is party.
She is a
also.
party.
That's all.
My lord, I need contempt, my lord, because it is already same thing matter is coming up. That's why I'm requesting my lord, to please read page 41, where BBMP Commissionerate has given, after going through all the arguments, his verdict, my lord. And which is already been proved that the kata obtained was not in a proper manner, and my counsel also has proved that this is not, and also it is being proved in the lower court also that they obtained the injunction by showing a fake kata, fake documents, and that plead has been rejected by the court. And again they are coming up with the same thing. I have to prove it, I will prove, my lord. But the question here is, first thing is, the sanction plan what he is talking about is 22, my lord. It is given in the month of June 22. I remember every date, my lord, because I am personally handling this case. And BBMP came to the inspection on 1/7/21, page number 19 of my petition, which says no plan sanction, which means before even construction, they have obtained the thing. They showed somebody else's thing. It is not right, my lord. And also, I don't want them to come. The reason for it is a contempt case. BBMP should have acted upon. It is more than 1.5 years, and it is more than 2 years since they have given the provisional and confirmation order. They are not, they are just getting hand in gloves with them, and they are not taking any action. And this is this case across Bangalore, my lord.
We'll consider orders for 10. For orders on 10. For orders on 10.
Even that Chief Commissioner order was stayed by this honorable court in that writ petition, my lord.
The stay, my lord, because they are again bringing the stay and trying to interrupt this court as well, my lord.
We'll see what can we do. We don't know what we'll do. We'll think it over. Yes, apply our mind.
Great.
This. Number 31. Umapati, yes.
For the petition in this matter, my lord.
21. It is very old matter, must not survive now.
Lords, actually, we have filed this petition to implement a government order dated 10/1/19 to shift a number of administrative and quasi-judicial bodies to North Karnataka, my lord. But till today, my lord, only 3 of the officers have been shifted. And 2 have been dropped, and the remaining, there is no update, my lord.
Hard learned advocate, sorry. Mr. This is administrative function entirely. This we have same. So give copy to. There is similar petition disposed.
My lord, but the prayer are entirely different, my lord. Their prayer is to transfer a number of other officers which are not in this list, my lord.
The petitioner herein is stated to be a practicing advocate who claims to be a public spirited person. He has filed this petition, styling it as a public interest petition, in which the prayer is made to direct respondents to shift all the offices which are mentioned in the order produced at the next array with required infrastructure, staff and amenities within a time frame. It appears that the full stop. The petition belongs to the year, the petition was filed in the year 2019. The notification of legal order sought to be implemented is dated 10/1/19, whereby the competent authority of the government, Department of Planning, Program, Coordination and Statistics has contemplated shifting of certain offices such as Krishna Bhagyan Jal Nigam Limited, Karnataka Irrigation Corporation Limited to the place of transfer indicated in the order to bring the administration to the closer of the citizens and to facilitate the purpose. Paragraph. The grievance of the petitioner shortly stated is that despite the said order having been passed, it is not fully implemented. And the shifting of offices has remained in paper. It is stated that the representation was submitted but has not yielded anything. The shifting of office cannot fall within the purview of public interest jurisdiction of the court, inasmuch as it is entirely an administrative function. Administrative function. And the decision will be governed by the administrative and executive considerations and exigencies. The court is not inclined to interfere with. The court is not inclined to entertain the present public interest petition. A support is also drawn from the decision of the This is of this bench in Uttara Kannada, Raithara, RAITHA, Raithara, Abhivruddhi Sangh versus Government of Karnataka, which was a writ petition number 5563 of 21, decided on 9th 5563 of 21 in the nature of PIL, Public Interest Litigation, decided on 9th August 2024, in which also the very notification was subject matter of consideration and the petitioner had right to implement the same. Where is that? It is to be noted paragraph that in paragraph 4 of in the following paragraphs, it is to be the following paragraphs from the decision in Uttara Kannada, Raithara, Abhivruddhi Sangha, Supra deserves to be noticed. 4 to 5.2, 4 to 5.3, full stop. In view of the above, nothing, no relief could be granted to the petitioner. It is dismissed.
This is number 32. To Parameshwaraya DC.
In this case,
Some time to file my statement in this.
in this case, my lord, matter pertains to PL, my lord. The respondents have not filed any objection, my lord, till today.
What is it about?
Please, my lord, the petitions of the villagers of the Kabbur village, my lord, Shumaga district, Sorba Taluk, my lord. The main avocation is my lord, agriculture and dairy farming, my lord. More than 1,000 livestock in the Kabbur village, my lord. The survey number 80 and 135, my lord, total 125 acres of land, my lord, for Gomal land, my lord. As per the census, my lord, Annexure A, more than 1,000, my lord, livestock in the said village, my lord, the already shortage of 135 acres, my lord, 175 acres, my lord, in Gomal land in the said village, my lord. But, my lord, the aspirant number 4 and 5, my lord, trying to grant the said land in some other persons, my lord, in the village, my lord, without complying rule 17 of the land revenue rules, my lord. Rule 97 is very clear, my lord. Unless permission by the deputy commissioner, my lord, he is only a competent person, my lord, convert the Gomal land to agriculture land, my lord.
You will have to file. Reply may be filed before the next date, put upon 11th of 9th of January.
Please.
This is number 33, the Rajeshwar.
I appear for the petition. This petition, my lords, challenge the demand notice for demanding payment of royalty, my lords, for the non-existent lease period. My lords have heard this matter on the last date of hearing, and the date was fixed today to pass orders.
In the light of the above aspects, the court's intervention is warranted, but solely on the ground of violation of natural justice. The impugned notice of demand is therefore set aside. However, this order will apply only to the extent specified herein. While disposing the writ petition, the following directions are issued. The impugned notice dated 3/6/23 is quashed, and the same shall be regarded as show cause notice. The petitioner is permitted to submit a response within 15 days from the date of this order. The petitioner may request any additional information necessary to respond to the impugned notice, and the same shall be provided by the respondent authorities. The respondent authorities are directed to consider the petitioner's reply and adjudicate the matter in accordance with law. After granting the petitioner a reasonable opportunity to present their case, the entire process of adjudication shall be concluded within 3 months from the date of this order. The court does not express any opinion on merits.
Great, great.
34 adjourned, number 35. Shiv Kumar N.
For the petitioner, my lord, this is regarding that fake stamp paper being printed.
I have filed the affidavit of the principal secretary, my lord. I filed it on 20th November 2024. Lord, undertaking to initiate action, hold an inquiry, initiate an action, my lord.
When action is initiated,
My lord.
Go to paragraph.
My lord, I have an internal page 3 at paragraph 6(4). My lord, submitted to my lord that comprehensive action report with details taken on all these fronts shall be reported to this honorable court within a period of 1 month by the principal secretary. My lord may have this after 1 month.
Which will include the actual disciplinary action taken.
Yes.
And my lord, respondent 23 is the society which is printing all this. Respondent number 23.
My lord, I don't appear for respondent.
I agree. Therefore, I'm saying a notice may have to
1
be.
month, you have said 1 month. So 1 month from 1911.
My lord, may have been
Anyway, we will put up on 10th of January.
obliged.
Any of the affidavit in reply. Put up on 10th January. Learned additional government advocate paragraph. Ms. Nilofer Akbar submitted that in view of what is stated in clause Roman 4 of the affidavit. Roman 4 of paragraph 6 in the affidavit. Comprehensive action report with details, including the details about the action disciplinary action initiated against the erring officers. If any. No, hearing official shall be submitted before the court.
Can I request was notice to be issued to 22 and 23, my lord, they are private.
Who are there?
Respondent 22 and
Not
23.
necessary. Now it
Yes.
is being acted upon.
Yes, no problem. No, please.
10th or to 10th of January, 10th of December, 10th of January,
Obliged.
not 10th of January. Let it be 20th of January
Obliged.
at 2:30.
Number 36, the Sampath Anand Shetty.
Appearing for petition in this matter, my lords.
Pardon?
Appearing for petition in this matter, my lords. Notice was ordered, my lords, and this is a matter of parity, my lords.
My lord, I'll file my statement. My lord may grant me some time.
A date may be fixed, my lords.
10th January,
Obliged.
in order to enable, send out to 10th January, in order to enable learned additional government advocate, Srimati Nilofer Akbar, to file reply.
37 adjourned, number 38, H.L. Pradeep Kumar.
37 I am here.
Pardon?
37 adjourned. 38.
38, I appear for my lord appellate's counsel.
What do you want?
37 I am supplied.
37, 50. Somebody has got adjourned to which? You are petitioner. In 37, you are petitioner. In 37, you are petitioner
Petitioner.
or appellant.
Adjourn.
Yes, for the petition.
Then, but appeal is adjourned, so it will go to, along with. Appeal is adjourned.
Appeal is not at all to be specific.
Appeal is already adjourned, therefore contempt petition will travel with the appeal, hand in hand.
Connected.
Therefore hand in hand.
No, my point is, in that appeal, the core object of filing the appeal was page number 6, para number 6. May I kindly be.
It is already adjourned.
Only that thing is enough.
Only on that day will you argue long, you make long arguments on
Sir,
that.
adjourn ಆಗಿದೆ 19th February.
ಅರ್ಜೆಂಟ್ ಆಗಿದೆ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಅಂತ ಹೇಳ್ತಾರೆ ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಮಾಡಿ ಅಂತ ಎರಡು ಒಟ್ಟಿಗೆ ಬರುತ್ತೆ Hardly possible.
ಬರ್ಲಿಕ್ಕೆ ಬರುತ್ತೆ. 19th January.
Next week.
No, next week.
Please.
Houseful.
ಇಲ್ಲ, without my.
Next, the whole entire week is houseful. All sessions. So, not 19th January. January is there, 19th. 20th January. 20th.
38.
Your Lordship, 38, I seek for a short passover. I'm led by Senior Advocate Dhananjay Joshi. He's on his feet in
Is what?
court number.
Appeal.
I appear for appellant, my lord.
Pass
I
over.
appear in 38.
If
for
it is
pass of the
urgent, then
complaint.
we'll pass over, otherwise beyond.
Anything at the convenience of this court.
In
is
fact, my
argued.
lord, this is a matter for admission because, Lord, an industrial plot was allotted, Lord, in favor of the writ petitioner. Thereafter, my lord, a request was made to make allotment in favor of a new entity. And that request was entertained subject to condition that the original allottee, Messrs. Mysore Kirloskar, should continue to hold 50% of the shareholding. And my lord, that has been violated now. So when a request was made by the new entity called Kirloskar EAF Limited, my lord, we treated it as, my lord, a new, my lord, allotment and imposed some penalty.
This can wait. 13th January.
28.
Number 39, Mr. Som Sundar Rao R.
Appellant, kindly see one week time, apply. Because of apply.
January 21. 10 or to January 21 as requested
Number
by learned group appellant.
20th January. Number 40.
I represent the appellant, my lords, kind leave.
The subject matter, my lords, was listed on 20th of November, my lords. My lords were pleased to issue notice and ordered the matter to be listed on 20th of January, please, my lords. It's listed today, my lords.
By mistake, by mistake.
Of urgency, I move the matter.
No, no, it is already in order. Next.
For consideration of interim prayer, my lord, I move the matter.
Then file IA. The appeal has been wrongly placed since the order dated 20th/11/24 indicates that notice is made returnable on 20th January 2020.
Grateful to my lords.
For first week, my lord, it may be taken, because my lord, my submission is, my lord,
No submission. Today it is not on board.
at least first week it may be taken first.
No, so you file IA, whatever you want to change, interim order, preponement, but today there is a judicial order, will change it.
Please. Grateful to my lords. Number 41, Mr. N. Suresh.
This case, my lord. My lord, the last occasion, your lordship has given instructions to contact the complainant regarding compensation instead of the alternative side. He is ready to accept for the
My lord, you know what
compensation
happened?
act as per the new act.
My lord, here there is a direction by the learned single judge, my lord, that a site should be, alternative site should be given because BBMP had acquired the said site. My lord, now the BBMP, my lord, we have filed a memo stating that there is no sites, but compensation would be paid.
We are ready for that as per the new compensation act.
That is a matter of merit now. What compensation? If you are agreeable for compensation, the contempt is closed.
Yes,
About compensation, it is a merit.
compensation would be paid.
Compensation, we are agreed as per the new compensation act.
That right may be agitated separately.
Yes.
In principle, you are agreeable to receive the compensation.
We are agreeable.
But how to be calculated under which law, it may be a matter of separate proceeding. Correct, we will dispose. Following were the directions issued by a single judge in his order dated 23rd May 2023 while disposing of the writ petition, extracting from paragraph 4. Yeah, sir, this writ petition. 11/7/22. The contempt is alleged in respect of non-compliance with the above directive, stating that the site is not allotted. In response to the notice of this court, respondent BBM, where is it?
Oh, BBMP, my lord, I filed a memo on 16/10/24.
Has filed, 6/6/20.
16/10/24.
Has filed the
Sorry, my lord,
response
in Kannada.
dated 6/6/24, in which it is inter-alia stated that in which, after narrating the actual background and the history of development, it is stated that the respondent, though made all sincere efforts and honest attempts to allot the alternative site to the complainant, as directed by the court, as directed by this court, the site identification was objected to, and it was not possible to identify or allot the site, which may have the clear title. It is stated that therefore a site with clear title is not possible to be allotted to the complainant. Where is the complaint about the compensation?
I have filed the objections also.
Thereafter,
We have filed a memo, my lord,
BBMP has filed memo. Where is that?
on 16/10/24.
On 16/10/24, which reads as under.
With the commissioners,
along with which order public endorsement of the competent authority is produced, dated 15/10/24 of the competent authority BBMP is produced, which is in vernacular and explained to the court to submit that it gives approval for payment of compensation to the complainant in lieu of the alternative site, which is not possible to be allotted. Full stop. In course of the hearing today, learned advocate for the petitioner on instructions of the petitioner submitted that the petitioner is ready to accept the compensation. Full stop. In view of above, the contempt proceedings are not continued and closed. Paragraph. At this stage, learned advocate for the petitioner submitted that the compensation should be calculated in particular way. However, this aspect is premature to be addressed in and not the domain, as well as it is not the domain of the contempt proceedings. Full stop. If the complainant is not satisfied with the amount of compensation which he will receive as agreed today, it will be permissible for the complainant to institute appropriate independent proceedings if permissible, in accordance to law in that regard. The court, however, does not express any opinion on merits, but is inclined to close the contempt proceedings. Accordingly, it is closed.
As per the new compensation of,
The compensations,
as per the new compensation.
at this stage, learned advocate for the petitioner stated that the compensation may be directed to be paid within
3 months.
within a specified time. Full stop. The compensation shall be assessed and paid within 8 weeks.
3 months. 3 months.
3 months. 3 months.
Public.
43 after vacation. You would
Serial number 71, my lord.
in the after 20th January.
71, serial number. Pray for some time to up.
Will we get the,
Serial number.
all now, all will go
Complied, your
after,
lord.
all will go after vacation.
It was complied in serial number 46.
We have to verify it.
So then verify then the 10th of December at 2:30.
Yes.
Serial number 58.
Court officer? ಸೆಟ್ಟಿಂಗ್ ಇದೆಯಾ ಮಧ್ಯಾಹ್ನ? ಇದೆಯಾ? ಯಾಕೆ 4 ಗಂಟೆ ಮೀಟಿಂಗ್ ಇದೆಯಲ್ಲ ಅದಕ್ಕೆ. ಓಕೆ ಓಕೆ.
Court officer? Court officer? ಹಲೋ
ಹೇಳಿ ಸರ್, ಕೇಳಿಸ್ತಾ ಇದೆ.
ಸರ್, ಮಧ್ಯಾಹ್ನ ಸಿಟ್ಟಿಂಗ್ ಇದೆಯಾ ಸರ್?
ಇದೆ ಸರ್, ಇದೆ.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು ಸರ್.
sitting with your own, yes.
My
What's our
lord,
matter? Still number 16.
my lords, kindly. Serial number 48, my lords, it was mentioned on 16/10/2024, and that the Gambhirdhan versus Gujarat State University matter was pressed into service UGC. Honorable Supreme Court has settled all the issues. Now it appears University Advocate has given no objection. It has come in orders in serial number 48, my lords. Again, last date it couldn't reach, the matter did not reach and it is adjourned. University appointments are made contrary to UGC regulations. Matter is little serious, my lords. In Karnataka, it's a PAL, co-warranto.
About PL about?
Appointment in universities contrary to UGC regulations. Now Supreme Court has settled the issue in Gambhirdhan.
So we'll take up immediately after reopening.
But this University Advocate has filed a retirement memo that it can be accepted, my lords. Advocates on record. UGC also has changed its advocate, and Bengaluru University has also changed its advocate. Both can be taken on.
What is the memo?
They have filed a memo for retirement, my lords. Both.
Not,
Retirement.
Advocates appearing for respondents apparently have.
So press
retired.
notice to go, press notice.
No, they are appearing. New
Appearing.
advocates are appointed.
Appearing, or
New advocates are.
today what is to be done?
New advocates statutory bodies. They have appointed new advocates.
For the judicial reward. So memo filed by learned advocate, Mr. Learned advocate for respond 2, as well as respond number 4 are accepted, and they respective learned counsels are permitted to retire.
And some accommodation at 2:30 or something. Any day after vacation.
Removed from the list, closed list. They are already appearing,
Other advocates are appearing.
these two respondents are already represented by other advocates.
Well, at some date.
Other learned advocates. Yes. 16.
Appear for the appellant.
When did it go?
Grateful.
Yes, thank you.
I'm sorry, there is a communication gap between the council and the court before the writ petition is concerned. In fact, Annexure A is not the subject matter of the writ petition. Kindly say the prayer in the writ petition, page 19. Learned judge has misconstrued the endorsement. In fact, we exhausted the remedies under section 136(2) as well as 136(3). There is miscommunication between the council and the court. Page 19, prayer in the writ petition. Issue writ of certiorari. Quash the impugned order dated 14/7/2023. Passed by the second respondent deputy commissioner in RP number 70 of 2022, void Annexure K. And the order passed by the third respondent assistant commissioner dated 21/3/2022 in RMIS 431 of 2016 at Annexure F. Bad could have been rest at the time. Further praise should not have been asked for, and the endorsement dated 24/10/2016 issued by the fourth respondent, Tahsildar void Annexure A. Annexure A's endorsement spent for itself.
So against order 14/7/23.
My lord, there's a challenge to the order of the deputy commissioner, my lord. So the modification is required, my lord, to the effect that an appeal would lie to the tribunal, my lord, under 49(2). 49(c).
This is 136(2). There is no appeal. It's only writ remedy.
There's a challenge to the deputy commissioner order in the writ petition, my lord. He has exhausted 136(2).
136(3).
130
No, there is no further remedy.
136(2) is exhausted, 136(3) is also exhausted, both assistant
there
commissioner.
is no
Writ is the only remedy.
So there is no further remedy.
Further
please.
remedy, my lord, 49(2) is would,
I'm sorry.
49 class C, my lord, if an order is passed by the deputy commissioner, then an appeal would lie to the tribunal, my lord,
I'm
under
sorry.
49.
There is no further appeal, it is only the writ remedy.
My lord, it's against the original orders, my lord.
136(2) refers to order is final.
My lord, this is the order in original, my lord. Therefore, 49 may not be applicable.
That's right.
Matter may be remanded back to the single judge, my lord, for consideration, fresh consideration.
The matter has to go back to the only single judge for.
Single
fresh
judge for
consideration.
fresh consideration.
Notice, because private party is there.
No, writ petition was dismissed at the preliminary stage itself, without notice to the parties.
Without notice to the.
Please,
Only R1 and to R5 were represented.
only the government was represented.
Represented.
1 to 5.
The preliminary
To
stage.
5.
May
So
be
we
remanded.
pass the order.
It has to the lordship.
We'll set aside the order,
Please,
the
please.
ground that the remedy is not available
Please.
as observed by learned single judge.
Remedy has already been exhausted.
40, we'll record your argument, 49 and reject it.
No, my lord, I am not insisting on that, my lord. That is only as against the order in original, my lord. This is a revisional order.
And request learned judge to decide on merits.
Please,
Please,
We'll pass the order.
please,
Within expeditiously, parties shall cooperate.
please.
So give the appearance and then, thank you. We'll pass the order.
Please,
The time is. not-
please.
Number 74, say 230 matter, to CM Venkat Reddy.
Yeah, 70.
ಅದು entry ಅದು sorry.
What is it about?
My prayer at the page number 22 one. Issue writ of mandamus to the response to 5. Immediately take over the custody of the entire Goma land in survey number so village. Further direction to the settlement to reserve the land for public purpose. Further direction restraining the registration of entering sale deeds in respect of the land in question by response number so and so. A direction to the government and other response authorities order to probe into the entire land grabbing scam and take appropriate action as per law. Further, issue appropriate writ or order declaring all revenue entries like Kata, so and so, in Goma land, so and so kuntas, situated at so and so, as illegally contrary to the provisions of Karnataka Land Revenue Act. My lords, further various directions has been issued by this honorable court and several statements also has been filed by the government. And the last, my lords, are dated further statement, 15/3/2022 statement. 15/3/2022. Latest statement of the government. It has been filed. 14/3/2022. It has been filed where here pursuant to the orders of this honorable court, 17/11/2009, order dated 15/11/2021, this statement has been filed. Status of land also has been filed. R2. March 2000. Government statement.
What they have stated.
So let's, this status report filed by the government pursuant to the orders of the sample court dated 15/12/2021. Well, let's status report R2 annexure may kindly be looking. R2 English translations. Well, let's subject regarding filing writ petition number so and so, before so on, documents illegally registering sale deeds after forming illegal sites pertaining the government Goma land in survey number so and so, so and so. Reference writ petition number and order dated. A case has been registered, writ petition number so and so, honorable court, regarding creating of fake documents and registering sale deeds after forming illegal sites, Goma land, government Goma land, an extent of 65 acres 33 quintas in survey number 81 Vitsandra village, Bengaluru. As per the Pahani pertaining survey number 81 Vitsandra village, Bengaluru, South, Kolkata has been entered in column number 9 respectively in the name of so and so 11 members. My lords, last paragraph. On verification of the documents, it is found that there is no original file sanctioning the grant of survey number so and so. Hence, as for the Pahani, no original documents are available to say how rights has been recorded in the individual's name, but there is a register known as Sagavali register, which shows that survey serial number 135, there is an entry regarding grant of total so and so acres and guntas, so to Jairam and 22 others in survey number 81 Vittasandra village. The order number mentioned in so and so, so and so, but there is no file concerning this order. Since there is mention of the order of Deputy Commissioner, it is necessary to obtain the said order from the office of the Deputy Commissioner. Yes, the proposal is sent to the conduct appropriate inquiry under section so and so, so and so. Thereafter, notice has been issued and cases has been registered. Further status has not been filed even today. What happens? The lands has been taken back to the custody of the government or not? Further statement has not yet been filed by the government. This is pursuant to the orders of this court 15/2021, present status. Present status explained and initiated action also. Notices has been issued and cases also has been next annexure. Cases has been registered. Further development, there is nil. No further development. What happened further? Status and everything. That has to be, further status has to be filed by the government.
So what is to be done?
My lord, the issue pertains to
Even there is a rule, government Goma land cannot be granted to any private individual, 22A Amendment Act. And it is not been granted to anybody. It is all fake documents. Lands has been acquired by the land grabbers. Even
My lord, may I make two submissions? My lord, first of all, the survey number pertains to 81, not 91.
81.
81.
81.
Now, my lord, as per the sale deeds produced by the petitioner, my lord, third party interest has been created. My lord, and as per the status report that is filed by the government, my lord, there are proceedings pending. My lord may have this on Tuesday. I'll bring it to the notice of my lord what has happened to these proceedings, and then I'll leave it to my lord. Where?
Which of it?
My lord, so far as me is concerned, 10 to 15, were all grantees of the year 1979. On the complaint made by these persons and because of this writ petition, the Deputy Commissioner has conducted detailed inquiry. All original documents are being placed before the Deputy Commissioner and he has found it is a genuine document. So far as me is concerned, 10 to 15. We are granted with 2 acres and remaining because total extent is 54 acres and that. So far as these grantees, even now, they are cultivating and there are downtrodden people and there are agriculture labor. They are in position, they are cultivating. By this frivolous petition, even my development of agriculture activities is also stopped and stalled by this person. And this person, he claims to be the news reporter and newspaper owner. 8 and 9 in the writ petition, there are local real estate agents and they call with due respect, land mafia. They have pursued it and they brought all pressure on these persons to sell it. They did not part this land to those persons. That's how this PL has come up before this humble court. It's not a public interest, purely a private interested litigation. For some with motive, they have filed this and all these poor persons and downtrodden fellows who did not concede to their demand is my respectful submission.
Welcome. Find out the status.
Yes, madam.
I filed my statement along with my grant certificate also placed on record, my lord.
Your phone number,
Number 10 to 15, my lord. I got myself implemented.
your reply is there.
Please, my lord, I replied.
It is for the government to say whether their documents is genuine or opaque of their further status of report. Actually, they have filed cases and inquiry is going.
We think that we'll be putting end to the matter
Yes.
on matter.
No, my lord,
Please, my lord.
Yes. Number 42. Sri N. Sukumara Jain.
This matter, we have filed our compliance report, my lords.
Petition.
This is with respect to the road, commuting of in the road, my lords, passing through survey number 36. Lords may kindly see paragraph 4 and 5 of the compliance affidavit, page 2 and 3, my lords.
Page number 8, my lord, is an order passed by the learned single judge, wherein it is specifically stated the grievance of the petitioner is non-implementation of the order of the year 2001 insofar as farming the road is concerned to access my property. And the learned judge further directed to consider the grievance of the petitioner. The 2001 order is not disputed. In their reply, compliance reply, annexure R1 at page 6, they admits that 2001 order, page 6, my lord, R1.
In paragraph 4, we have clearly given an endorsement stating that the road can be used for public
No, I'll make it.
commuting, my lords, which is going
In
to survey
first
number
page,
30.
as per the above subject reference, Mary Rose Ramani, so-and-so, village in survey number 76-2 and other survey numbers, it is ordered wide order dated so-and-so, 29/12/2001 for reserving the road, my lord. In this, for consideration, what they have done, they have repeated the same order wherein they have stated you are permitted to make use of the road. Permitted to make use of the land instead of farming the road. So according to me, there is no consideration at all, not consider the grievance of the petitioner. In the last para, page 7, it is hereby informed that it can be used for public purpose as marked in the map. So that order is already existed in 2001 itself. That is reserved for road only. Page 7, the reply, annexure R1. It is repetition of the earlier order. 2001, that order is made. Land is reserved for road. Again, they will say you are permitted to make use of the land. So according to me, there is no consideration at all, even though there is no specific direction. Consideration means they should go forward one step further than the existing order, which is already in force.
Page 7, my lord, last line. Page 7, annexure R1, last line, they will say, according to the order of this honorable court, Assistant Director of Land Records has submitted a map as reserved for a road in survey number so-and-so of so-and-so village. And it is hereby informed that it can be used for public road as marked. This order is passed in 2001. They also refers that order.
Lords, may I submit, my lords, that land was granted to police department.
So land is already reserved for making use of as a road.
For orders. on
Because
Wednesday.
one further, because my learned friend told the land is reserved for police. They are abutting to this land. That's a sufferent land in the same survey number. The annexure R2, the Tahsildar specifically writes to the police department, this particular road is reserved for so-and-so. Don't disturb them. There's the annexure R2. Against police also they have written, very same authorities.
We'll pass whatever order we pass.
Like,
It is repetition of the old order, that's all.
Serial number 49, my lord. 49, my extremely. Lord, this has been adjourned 5 times previously, my lord. Very bad smell is emanating from a public park which is illegally occupied, my lord. They are rearing pigs, my lord. In serial number 49, my lord. This is a public park, my lord. Very bad smell is coming, my lord. Unbearable smell, my lord. It is extremely difficult to breathe
11.
in that area, my lord.
11.
11, this month, grateful.
Serial number 52, your lordship. PF was already paid. There was a conditional order for payment and then it's paid to be granted. We have paid, made the payment of 3 lakhs and 60,000 rupees. Kindly pay for the stay. I pray for the stay, your lordship. There was a conditional stay.
Let it be taken up, not in.
Of 9th is a matter at 8th.
9th will keep.
Still number 55.
Yes, ma'am.
serial number 65. 65, we've completed. 65,
All matters, how can we keep it? 17.
my lord,
Still
65.
number.
Just one office objection, that is for counsel, only the accused number 1. In the writ petition, it says that it's represented by the sub-registrar. But actually it is by the IGR, my lord. That's only, if that may be
The
overruled.
office objections is dispensed with for the time.
My lord, serial number 59. About 200 students are in jeopardy, my lord.